Real estate is more than contracts and closings. It's the constant balancing act between ethical decision-making, legal compliance, and client trust. In this section, we'll examine real-world case studies that highlight how Arizona agents can handle difficult situations involving title, escrow, and client communication. Each scenario is drawn from common ADRI investigations or industry practice, emphasizing lessons every licensee can apply immediately. Case Study 1. The Earnest Money Mix-Up. A Phoenix buyer delivered a $10,000 earnest check to their agent on Friday afternoon. The agent didn't turn it in until the following Wednesday because they got busy. Over the weekend, the buyer decided to withdraw their offer and requested the check back. When Escrow received the funds on Wednesday, the seller refused to release them, claiming the contract was already binding. The buyer filed a complaint with ADRI. Analysis. The agent violated R428-802A by failing to promptly deliver the funds to escrow. Even though no theft occurred, the delay created confusion, risked civil liability, and led to a formal letter of concern. Agents must treat client funds with urgency and document every handoff to ensure compliance with ARS. Paragraph 32.2.151.01. Case Study 2. Early occupancy gone wrong. In Mesa, a buyer asked to move personal items into the garage 3 days before close of escrow. The listing agent verbally agreed but did not obtain written authorization from the seller or broker. When the buyer's financing fell through, the seller demanded the items be removed and damages were discovered. The seller filed a grievance with ADRI. Analysis. Under R4-28-1101J, agents must not permit occupancy or possession before COE unless written authorization exists. The listing agent's verbal approval violated ADRI rules and exposed the broker to potential liability. Ethical practice requires agents to protect all parties, even when pressured to make things easier. Case Study 3. The Hidden Easement. A Flagstaff buyer purchased a property with plans to build a guest house. After closing, they discovered a recorded easement allowing the neighboring property owner to use part of the land for utility access. The easement was disclosed in Schedule B2 of the title commitment, but the agent never discussed it. The buyer filed a complaint claiming non-disclosure. Analysis. The agent violated R428-1101E by failing to disclose a material fact affecting property use. The easement was a matter of public record and should have been explained during escrow review. Agents have a duty to help clients understand the title report, even if it means consulting the title officer for clarification. Transparency is the foundation of ethical practice. Case Study 4. Title Insurance Misrepresentation. A Tucson agent told a buyer that title insurance covers any problem with the property, including future liens or HOA issues. After closing, a $3,000 unpaid special assessment was levied by the HOA, and the buyer realized it wasn't covered. The agent was reported for misrepresentation. Analysis. This scenario reflects a violation of R4-28-1101H, competence, and ARS paragraph 32.2E153A3, misrepresentation. Agents should never make blanket statements about coverage. Title insurance protects against past defects or encumbrances existing before COE, not future obligations. The ethical agent defers such questions to the title officer, ensuring clients receive accurate, legally compliant information. Case Study 5. The Undisclosed Judgment. During a Chandler sale, the title company discovered a $15,000 judgment lien against the seller. The listing agent knew about the issue but assumed title would figure it out. Because the seller couldn't clear the lien, the buyer canceled and demanded reimbursement for inspection and appraisal fees. The buyer filed a complaint citing misrepresentation. Analysis. The agent violated R428-1101E for failure to disclose known material facts. Agents must immediately disclose any information that could affect a buyer's decision or the transaction outcome. Assuming escrow will handle it is not an ethical or legal defense. The agent's silence caused financial harm and triggered ADRI disciplinary action. Case Study 6. Wire Fraud Attempt. An agent in Scottsdale received an email that appeared to come from Escrow, instructing the buyer to wire funds to a new account. The agent forwarded the message without verifying its authenticity. The buyer wired $48,000 to a fraudulent account. Although the FBI later recovered some of the funds, the incident resulted in a civil lawsuit. Analysis. While not a statutory violation, the agent breached R428-11101A, duty to protect the public interest. ADRA emphasizes cybersecurity awareness and requires licensees to educate clients about verifying wiring instructions directly with escrow officers. Ethical duty extends beyond paperwork. It includes protecting clients from foreseeable risks. Lessons from these cases. Each of these real-world examples reinforces a core principle of Arizona real estate practice. Ethics and compliance are inseparable. The most common ADRA disciplinary themes, misrepresentation, non-disclosure, delayed delivery of funds, and premature possession, are entirely preventable through communication, documentation, and education. Agents who understand and apply ARS Titles 6, 32, and 33, along with R428-11101 and R428-802, safeguard not only their clients, but their own professional standing. Key takeaways. Ethical dilemmas in title and escrow often begin as small oversights, a late deposit, a missed disclosure, or a poorly worded statement. Yet every oversight has the potential to damage client trust and lead to ADRI sanctions. The ethical agent leads with honesty, follows the law, and seeks guidance when uncertain. Acting with transparency and integrity is not just compliance, it's good business.